I'm very pleased to be here, and I look forward to a thorough discussion of some of these issues. And so I'll try and be really deliberate in terms of my presentation and timing. I know we'll take a break in about, or not a break, but in about 40 minutes, we'll have opportunity for Q&A and a little bit of a break, and then continue with my remarks. I'm going to switch over, hopefully, fluidly to a PowerPoint. So I hope you all can see that. I don't know, Karen, thumbs up? Okay, great. Needless to say, today's topic relates to what's commonly known as DACA, or some people refer to it, the Dreamers case. And I want to talk about, obviously, the specifics of this case, but I think it brings out, obviously, some larger issues about the law, about immigration. And it's particularly appropriate that we talk about this case today. I don't know how many of you listened to the news, watched the news, read the news today. There is a lot of talk about a case that came out of the Ninth Circuit in California regarding immigrants or those who are designated with temporary protected status. And it may result in the deportation of a few 100,000 individuals who have fled civil war and environmental devastation. And that case, that decision by the Ninth Circuit, relies principally on this DACA case. And so we will get into that as well, but just as is always the case with law, the precedents, the outcomes that come from one case have a wide range of effects. The DACA case really does span two administrations. And while at times when we talk about law, we want to avoid partisanship, we want to avoid politics, and in many respects, the DACA case sort of really resists that admonition. It is a policy that began in the Obama administration and then is rescinded in the Trump administration, all the while affecting hundreds of thousands of young people. And I think it's safe to say that the United States immigration history is a fraught one. There's almost I don't know what the psychosis is. I don't know if we have any psychologists or psychiatrists in the group here. But when we battle with immigration, on one level, this is the American identity, a country of immigrants, melting pot. And at the same time, I think that is in tension with, on one side, virulent xenophobia, but also maybe a more understandable struggle with, what is our identity if we are a nation of immigrants? What binds us culturally? How do we address different cultural backgrounds? How do we address different ethnicities and histories and languages and race? All of those, I think, are invariably caught up when we talk about law and immigration. And if I might just digress for a moment, but I think it's useful to remember, one of the primary grievances that the colonists held against the King of England were actually his limitations on immigration. And so the framers of this country, I think, were struggling at various points, both at the Constitutional Convention and thereafter in the early stages of this country through to today, as to what is our identity as a country and how does immigration factor into it. It's worth noting 7 of those who signed the Constitution were immigrants themselves. And yet, of course, we constantly have this nativism and this struggle. Now, the Constitution, I think it's important, and it's an important bedrock for this case, provides the power, authorizes Congress to establish a uniform rule of naturalization. So Congress is given the primary authority to address immigration. A lot of that authority is delegated to the president. And so we are dealing with these two political branches, and who has the primary authority is always at tension. It's worth remembering that probably the first act by Congress passed on immigration provided that all free white men may become citizens of this country, which in some respects at that time was a remarkably progressive decision, allowing people to come into this country and gain the privileges of citizenship. Of course, as I've just laid that out, I said all free white men. So those who are not free are not included in that compact. Women are not included in that compact. And anyone who is not white is not included in that compact. And I think, you know, we see many of those tensions that play out today, perhaps in the DACA case. Again, just a little bit more of history that I might provide to you to go back. You thought you were hearing about the Roberts Court. I'm going to go back to the late 19th century and the pivotal case, United States versus Wong Kim Ark. That case is really the case that originated or cemented judicially the idea of birthright citizenship. Now, this case, you can see this is you know, some of the key documents of Mr. Wong Kim Ark. He was born in 1873 in the United States. He was born to Chinese parents, to immigrants. By 1882, the United States had passed the Chinese Exclusion Act, which meant that Chinese could not come into the United States. It was a time where many of the Chinese immigrants, a significant number, but relatively speaking in terms of the immigration population, small, had come into this country and, you know, were brought in many respects to do some of the lowest level work, the lowest paid work, dangerous work. But anti-immigrant sentiment, anti-Chinese sentiment grew, and the Anti-Exclusion Act was passed. Well, Wong Kim Ark was visiting China, and he returns to his homeland, to his homeland being the United States, I should say, in 1894, the country where he was born. And customs officials don't allow him in. They don't allow him in because he's Chinese, because the Anti-Chinese Exclusion Act should apply to him. And he argues, wait, I'm an American citizen. The case went all the way up to the Supreme Court, where the court ultimately held that Wong Kim Ark is indeed an American citizen and benefits why? From the 14th Amendment, right? Which provided all persons born or naturalized in the United States are citizens of the United States. Heretofore, there'd been arguments made, no, that really only applied to white men. Maybe the 14th Amendment had been a pass to address slaves, but not the Chinese. And here, the Constitution is upheld, and a notion of citizenship for all prevails. Well, let's now come a little bit closer. Sorry, no, that's not. To today's time and the Deferred Action for Childhood Arrivals policy. It's worth remembering, many of you probably do, that in the early 2000s, Congress over and over again, bills were passed to try and craft some sort of immigration reform. We can probably remember gangs of 8 in various groups and discussions in Sturm and Drang over amnesty for immigrants and a legal pathway and what have you. And needless to say, none of these bills passed. A couple of dozen bills were passed in the aughts. And you may recall also that President Obama was called by many in the immigrant community the deporter-in-chief. And those deportations resulted in separations of family, as this banner suggests and protests. And so in 2012, some may ascribe it to humanitarian motivations, others may ascribe it to politics. President Obama passes, or does not pass, sorry, his Department of Homeland Security under the Secretary Janet Napolitano introduces by a memorandum a policy known as Deferred Action for Childhood Arrivals. And it does a few things. It allows certain unauthorized aliens who arrived in the United States as children to apply for a 2-year forbearance of removal. So kids who had come with their parents, presumably not through any will of their own, but following their parents, could apply for a 2-year deferral of removal. Right? They're unauthorized. The government is within its rights to remove people, deport people, but they can apply essentially for some leniency and a deferral of that removal. And if they are granted this relief, they can also apply for work authorization and Social Security and Medicare benefits. So this policy, as I said, is introduced in 2012, and about 700,000 aliens, non-citizens, have taken advantage of this opportunity. So certainly, needless to say, a significant number of people. These are the dreamers, right? A group of people who, by all accounts, the country is sympathetic toward. Polling, regardless of party, their hearts go out to these individuals, and so this is this group of individuals who we are familiar with, right? This is DACA. So at the heart, though, of this policy, right, how can, if these individuals are illegally here, however sympathetic their story, how can we defer their removal? Isn't that perhaps unlawful? Doesn't it maybe go against congressional enactments over immigration and the legality thereof? Well, to get some sense of an answer, we need to go back to, well, I guess this is really the 70s. I was going to say the 60s, but to the Beatles, and more specifically, John Lennon. John Lennon had overstayed his work visa to be in the United States. There he is with Yoko Ono. But he wanted to stay. I can't remember exactly the quote, but he liked making music here. This is the music that he was most drawn to. He didn't want to leave. And the government, I think at the time it was President Nixon, was no fan of Lennon's, wanted him out. This hippie troublemaker. And Lennon and his attorneys tried to start figuring out, well, not all immigrants are getting booted out of this country. What's going on? And lo and behold, they discovered, and it's not necessarily the most novel legal term, but prosecutorial discretion. Right? That is, prosecutors in a criminal context, right? They don't prosecute every bad guy. They have discretion as to whether they take pleas or for how much they may try and seek a conviction, a sentence for. Similarly, in the immigration realm, there is prosecutorial discretion, and there may be a deferral of removal. Right? There is inevitably a prioritization, right, of who should be deported. Depending on the numbers that you see, there are 11 million, 12 million, 13 million unauthorized individuals in this country. It's not possible for the government, no matter how aggressive, no matter the resources, to deport everyone at once. And so, connected with the Deferred Action for Childhood Arrivals program, President Obama decided to prioritize certain higher level criminals and defer prosecuting the dreamers. And so the memo provides, that look, as I mentioned, these are young people who were brought to this country as children. They didn't mean to violate the law. They don't have the intent. And now they are productive contributors to our society. And they have known only this country as their home. And I should say some of the DACA requirements were individuals who either were in school, had gotten a GED, they could not have a serious criminal history, they could not pose a security threat. And so based on this low priority status, the Department of Homeland Security, the agency tasked with issues relating to immigration, decides to defer removing them, to forbear from removing them. So this is DACA. This is the structure we have of DACA. I have to introduce, of course, this is a law section, another acronym, DAPA. So we've got DACA and we have DAPA. In 2014, the Obama administration, and again, specifically the Department of Homeland Security, authorized deferred action for the parents, 4.3 million parents, whose children were either US citizens or lawful permanent residents. So individuals who maybe had come to this country illegally, unlawfully, they have children born here. Now they are the parents of citizens. What is going to happen with them? Right? And this is the concern. Again, you go back to that banner you saw earlier, the separation of families. If we deport the parents, the children stay here. This is not a tenable situation as far as the Department of Homeland Security was concerned. And so it was proposed through DAPA that there would be a deferred action for the parents. And parents would enjoy essentially the same benefits and entitlements that were afforded under DACA. Right? So deferral of removal, work authorization, Social Security, Medicare benefits. Now, however, we have our first key interruption by the courts. Starting with the Southern District of Texas, followed by the Fifth Circuit, the courts ruled that DAPA, not DACA, DAPA, violated Congress's designation of particular classes of people, of immigrants, unlawful immigrants, who could receive work authorization and benefits. So again, we have a policy similar to DACA that the lower courts, the Fifth Circuit, an important federal appellate court, issues this ruling saying that these benefits violate, contradict the Immigration and Nationality Act's provisions about which classes of people who are unlawfully here can receive benefits, can apply and receive the privilege of working. And the Supreme Court actually takes this case, and it happens, it coincides with now deceased Justice Scalia's death. And so the court comes to a tie, ruling 4-4. And so it essentially affirms the Fifth Circuit decision. And so this is the ruling, right? DAPA is unlawful because it has identified these classes and is providing them benefits, contravening statutory rules. So into this mix, right, we have DACA, we have these DAPA rulings, we have a change in administrations. President Trump comes to office. And President Trump, I think it's safe to say, ran a campaign that if it wasn't his primary plank, it was certainly one of his top planks on issues relating to immigration. And so from his campaign speech, and this is from August of 2016, he said, "We will immediately terminate President Obama's 2 illegal executive amnesties in which he defied federal law and the Constitution to give amnesty to approximately 5 million illegal immigrants." Well, both based on his characterization here and the math, it stands to reason that he is particularly identifying here DACA and DAPA, the 700,000 Dreamers and the 4.3 million DAPA parents of Dreamers and of other individuals. So this is a plank the president has run on. And while I think it's safe to say President Trump, like many of those, you have campaign promises, and many of those he did live up to. But early in his administration, he expresses sentiments that I guess could be characterized as some level of sympathy toward the Dreamers, and maybe having differing thoughts. And so he noted here, this is one example, they are here illegally. They shouldn't be very worried. I do have a big heart. We're going to take care of everybody. Where you have great people that are here, that have done a good job, they should be far less worried. We'll be coming out with policy on that over the next period of 4 weeks. I think some of you may remember, hearing the news, I loved the Dreamers, was something he said often. And so the issue of the Dreamers, I think was a bit of a political hornet's nest for the president and for the administration, what to do, having run at times what might be characterized as an anti-immigrant campaign, and yet the Dreamers sort of, again, this fairly sympathetic group. And at times, you may recall, during budget negotiations, it became at times something wrangled over and a chit to be haggled. Well, so we have these differing sentiments from the president, but ultimately, the administration, and specifically, again, the Department of Homeland Security, issues a memorandum rescinding DACA, right, terminating DACA. And this is a photo of the then acting Secretary Elaine Duke, who issued her own memorandum. Now, the Attorney General had made a determination, then Attorney General Sessions, based on the DAPA ruling, that DACA was unlawful. So this is the chief law enforcement officer making this ruling. It is authoritative for the rest of the administration, for the rest of the cabinet members. And so Secretary Duke writes in her memo that DHS will terminate DACA because of the court's rulings that DAPA, again, was unlawful due to the conferral of benefits. And it means, in all likelihood, that DACA will be ruled unlawful. And there's then just going to be unnecessary costs and burdens, right? So we have something that is of dubious legality based on the DAPA precedent. We shouldn't really bother, continuing this policy. That's what the memo says. And then there is a wind down process, if you will. The government will no longer, DHS will no longer accept new applications. It would allow 2-year renewals for those who are within a 6-month period of expiration. And everyone else's grants of benefits and work will expire on their own terms, right? So they're not going to be eliminated immediately, but they're going to be wound down. Okay, so this is the memo, the chief document, the chief instrument, if you will, that rescinds DACA, that eliminates DACA. And so now we finally come to the Supreme Court, right, to the case. Obviously, right when this was announced, there were lawsuits filed all over. Dreamers very anxious about what this meant for their status in this country. In applying for DACA and receiving both the deferral and then benefits, individuals shared information with the government. Suddenly, individuals were very nervous. Have they put themselves at legal jeopardy? If indeed they've been, had previously been hiding and now they had, if you will, outed themselves, now, they can be found. And so, great fears in the community over, imminent deportation or what have you. So within the case, there are 2 specific issues. One that we'll spend a good amount of time talking about is whether the rescission was arbitrary and capricious in violation of the Administrative Procedure Act. The Administrative Procedure Act is, in some respect, one of the most important acts that many of us don't often know much about, but controls so much of our lives, because so much of our lives is subject to various government agencies, right? Administrative law, administrative power, so Social Security benefits and determinations. And here the Homeland Security must act pursuant to the strictures of the APA. So the question is here, and it's very much a procedural one, though it gets enmeshed with substance, but was the elimination of DACA, the rescission of DACA, arbitrary and capricious, right? So that's that. We'll pull apart a little bit what that means. Secondly, was the rescission, or did the rescission infringe, violate the equal protection guarantee of the Fifth Amendment due process clause? Specifically here, the claim is that the lion's share of individuals who are dreamers are Latinos from Mexico. Have they been discriminated against? Is there an invidious purpose of discrimination behind this termination of DACA? Right? So these are our two primary, or really our two sole legal issues, though of course we will pull them apart a bit. So here's our court. I'm not going to try to use my pointer right now, but the court rules, and maybe we'll just go back to a moment, on the first issue, the court rules that indeed the rescission was arbitrary and capricious in violation of the APA. And on the second issue, a plurality of the court rule that the rescission did not violate the Equal Protection Clause. Now, I think it's safe to say the outcome was a bit of a surprise. While one can never put too much stock in oral arguments, it didn't seem to be finding so much favor with at the very least 5 justices, which is of course the only math you need to do. How do you count to 5? But surprisingly, with Justice Kennedy no longer playing the swing vote role, right there in the middle, the Chief Justice is the 5th deciding vote, along with the traditionally 4 liberal or Democrat appointee justices. So the lineup in finding that the rescission of DACA was arbitrary and capricious are Justices Breyer, Sotomayor, Kagan, Ginsburg, and again, the Chief Justice. And he writes the opinion, the Chief Justice does. On the equal protection claim, however, siding with the Chief Justice are Justices Breyer, Kagan, and Ginsburg. Justice Sotomayor does not join and writes a dissent on the equal protection claim. And while Justices Kavanaugh, Alito, and Gorsuch dissent from the arbitrary and capricious ruling, they have no qualms and would go ahead with the equal protection ruling. So for all intents and purposes, the arbitrary and capricious determination is 5-4, and the equal protection claim, finding that there is none, is 8-1. Well, let's explore these rulings then a little bit. First, before we can even get into a case, the court often has to address, can they even review the case? And this is often a critical issue in administrative procedure law, because in many cases, there is a notion that the agency is given what is really an entirely discretionary action or determination to make. And it's not something for the court to second guess and question. And so here, this determination about whether individuals, whether their removal, the government can opt to defer removing them, the government argues is an entirely discretionary act. Right? The government argues that DACA amounts to an agency non-enforcement action. Right? We've chosen not to do something that we are within our rights to do, which is to remove them. That's usually left to agency discretion. And if DACA is therefore discretionary, so too should the rescission of DACA be viewed as a discretionary act for which there is not judicial review, right? Great deference to the agency. Chief Justice Roberts, in his opinion, however, holds that DACA isn't simply a non-enforcement policy. Now remember, what we've just described is a pretty massive program, right, involving 700,000 people. And in addition to deferring removal, they may receive benefits, they may receive work authorization. And so he characterizes the program as one of conferring affirmative immigration relief, right? So this isn't such a simple process in which the court should just sign off. These are, in essence, intensive adjudications that are being made. And so Chief Justice Roberts rules the program and its rescission are therefore reviewable, right? The court can take this case, all right? So now we get to our key issues. So the Administrative Procedure Act, as I alluded to, really governs what agencies can do and how they can do it. And while even under review, the review that a court undertakes in exploring whether an agency has taken appropriate action remains a fairly deferential one. It's not a particularly rigorous review. Really, all the agency needs to do is provide a reasonable explanation or an adequate explanation for its action. In legalese and in our Administrative Procedure Act language, we call that, or an unreasonable action, right, is to make a determination or take an action that is arbitrary and capricious. Right? So these are really, these two framings are really one and the same, right? Was DHS's decision to rescind DACA, to eliminate DACA, arbitrary and capricious? And the court, as I've said, comes to a determination that it was, in fact, arbitrary and capricious. They did not provide an adequate explanation for two reasons. And the first is essentially that they didn't look at everything, right? That the memo from Secretary Duke doesn't explore everything involved. The issue is whether Secretary Duke failed to consider important aspects of the problem before her. And the court looks at a fundamental administrative law case, Motor Vehicle Manufacturers Association of the United States versus State Farm. Right? So we're all familiar with State Farm car insurance. And here is this pivotal case that Chief Justice Roberts rests much of his reasoning on. This case involved a government agency, the National Highway Traffic Safety Administration. And they issued a ruling that required motor vehicles had to have either a safety belt, a seat belt, or an airbag. And 4 years later, after this rule went into effect that the agency had issued, they determined that seatbelts weren't really all that effective in protecting people. And so they abolished the rule in full. Right? There'd be no passive restraint requirement whatsoever, neither seatbelts nor airbags. Well, there was litigation over this, and the Supreme Court ultimately ruled that the justification by the agency was arbitrary and capricious. It didn't make sense. They had only found that seatbelts weren't effective in protecting people. There'd been no determination that airbags were not effective. And so that ruling by the agency, that action by the agency was arbitrary and capricious because there'd been no consideration of the airbag safety, right? You need to consider things in full. You sort of had half a factor, right? You didn't have the full reason. So taking this case, taking the reasoning from here, Chief Justice Roberts says that is what Secretary Duke's memo has failed to do. It has failed to consider the whole picture because the memo, if you recall, right, relies on the illegality of DAPA. But remember, the Fifth Circuit had ruled that DAPA was illegal because it conferred benefits and work authorization on individuals that the Immigration and Nationality Act had already addressed and precluded in some instances. The DAPA decision by the Fifth Circuit, according to Chief Justice Roberts, did not address the issue of forbearance or deferral of removal. That is, that DAPA was struck down, right, only on the grounds of the benefits and work authorization, right? Again, like the State Farm case, there had only been a determination that seatbelts were not protective. There had not been a determination that airbags were not safe. Similarly, the Fifth Circuit had not made a determination that DAPA was unlawful because of the deferral of removal. And so the court ruled Duke's failure to consider forbearance or the option of even retaining forbearance without benefits, right? Let the dreamers stay in this country, but don't provide them benefits. There'd been no consideration of that factor. And so there had been a failure to consider. And this constituted an arbitrary and capricious action, an unreasonable action by the agency. Now, this would have been enough to hold the act unlawful under the APA, but Chief Justice Roberts looks at another factor as well in his opinion. And these are reliance interests, which I think are probably easier to come to terms with what we might be talking about here. Here, the question is, you have had the dreamers for a number of years now taken a host of actions based on the government's DACA policy. They've provided their information. They have set up lives here. And there are reliance interests. They have relied in good faith, right, on this policy. The memo failed to take into account these reliance interests. And according to Chief Justice Roberts, in reviewing an agency action, we need to find that those reliance interests are considered. And Chief Justice Roberts lists a host of reliance matters that involve the dreamers and other parties significantly. So, as he notes, since 2012, DACA recipients have enrolled in degree programs. They've embarked on careers. They have started businesses, purchased homes, even married and had children. And the impact on the DACA recipients' families would include 200,000 US citizen children, so that is children born to dreamers. There'd be an impact on the schools where DACA recipients study and teach, and on employers who have invested time and money in training them. There were a host of amicus brief, friend of the court briefs filed, stating that billions of dollars, that businesses had invested would be lost. And that here relates to some of this, excluding DACA recipients from the lawful labor force could result in the loss of $215 billion in economic activity and in an associated $60 billion in federal tax revenue over the next 10 years. So these were the reliance interests that Chief Justice Roberts found had not even been considered at all, right? There could be arguments made as to whether those reliance interests could be addressed, whether they're not as significant as stated here in the slide, but they hadn't been addressed at all. And so this was a failing that also rendered the rescission of DACA by DHS arbitrary and capricious. That is the Administrative Procedure Act claim. But Chief Justice Roberts also addressed the equal protection claim, which I should note was a bit of a surprise. The parties actually, before the Supreme Court, had not been asked to brief this issue. It was not an issue argued at oral arguments. It had been a claim brought up in the lower courts, but the Supreme Court had not initially taken this. And so it was a bit of a surprise that the court addressed this issue, or I should certainly say it was a surprise to me. The question here regarding this claim is essentially, did discrimination motivate the DACA rescission? Right? Was DACA terminated out of what's often also referred to as invidious discrimination? Was there a discriminatory purpose behind ending DACA? And there is a standard test that we look at to determine this. It comes from a case called Arlington Heights. And you look at three factors. Is there a disparate impact on a particular group? That is a particular group feel the brunt of this policy more than others, and in a disproportionate manner? Have there been departures from the normal sequence? So is this the out of the ordinary process, or was this business as usual, right? Was this the regular system working, or did something different happen? And then we look at contemporary statements by the decision maker. So what was said while this policy was being enacted? And some of the evidence raised what was the following. With respect to disparate impact on a particular group, the plaintiffs alleged that 78% of the Dreamers, 78% of those who would be affected by this rescission were Latinos from Mexico, 78%. So arguably a disparate impact. With respect to the rescission, the argument was, and perhaps it was captured a little bit in even the remarks from President Trump, but initially determinations by DHS that DACA was fine, or certainly hadn't disturbed it, and then there was a change in policy. And so the allegations by the plaintiffs were this was an unusual process. If it had been blessed shortly before and then is rescinded, that suggests that it is not business as usual. And then finally, with respect to the contemporary statements, these are some of the, at times, vitriolic statements made by President Trump, at least in his campaigning, anti-Latino, anti-Mexican statements, likening them to criminals and the like. And so it was on these that the plaintiffs relied. Chief Justice Roberts, again, writing for a plurality, so Justices Breyer, Kagan, and Ginsburg joined him on this, but not Sotomayor, ruled that as for disparate impact, most, or certainly a vast majority of immigrants were Latinos from Mexico, and so it stood to reason that there would be this so-called disparate impact. He even noted if this will be a factor, then essentially all immigration law, all immigration rules may be susceptible to equal protection challenges. He was fairly dismissive of the argument about departures from normal procedural sequence, contending that, look, administrations change policies. Within an administration, the policies change. That's not so unusual. And with respect to the statements that were identified, attributed to President Trump, essentially the argument was that they weren't all close in time, and they weren't all even necessarily within the same context. That is to say, he had issued statements that weren't, some of the anti-Mexican or anti-Latino rhetoric was not necessarily uttered in the context of DACA and certainly of advocating rescinding DACA. I am mindful of where we are on time, and I think actually this is probably as good a time as any to take a pause. In the second half of my remarks, I want to talk a little bit about the dissents in the case, a little bit about sort of how did this decision come to be, and really what is the impact going forward for the Dreamers and others. But I think this is a good opportunity to take some questions. So I'll figure out how to stop my share and look at everyone. And I don't know if I take the lead in taking questions, or if Karen, if you moderate this.
Whichever you would like. You can open the chat and Let's see, or if people wanted to unmute themselves and ask questions.
Were there circuits that were in conflict with the Fifth Circuit's decision?
No. So we only had the Fifth Circuit decision. The litigation worked quite quickly with respect to the DAPA litigation, as both sides have often done, and maybe at times both sides have criticized. The challenge to DAPA was brought very intentionally in the Southern District of Texas, where they felt they had a sympathetic court, and indeed they did. That one single judge issued a nationwide injunction enjoining the whole policy. It was quickly appealed, and the Fifth Circuit ruled on it.
I think that Roberts was one of the four who voted that DAPA was unlawful back in 2016, and yet he wrote. Well, first of all, he voted that DACA was, or the rescission was not proper. Do you think he was motivated purely by legal issues, or do you think there was some political consideration that led him to change his opinion, or in a certain sense, change his opinion?
Yeah, no, it's a great question. You're stealing some of my thunder, Mr. Schnall, from what I'm going to talk about later, but I'm happy to address it right now. So as you rightly point out, we referenced the DAPA decision and the 4-4 tie. Chief Justice Roberts was part of that foursome who ruled that DAPA, or would have ruled anyway, that DAPA was unlawful. And so how do you make sense of the change? I mean, I think if Chief Justice Roberts were pushed, he would insist that these are different determinations. What he was looking at, and again, what he highlights here, is that DAPA, and what they were ruling and looking at from the Fifth Circuit, was only the issue of the benefit, the conferral of benefits, the conferral of work authorization permits, and not the issue of deferral of removal. And so that might be a way that he would, by sort of the four corners of the page, distinguish the two policies. Now, we might decide that that's too clever by half, and so maybe get to your larger, I think, political question. What was Chief Justice Roberts doing here? My colleague, Jonathan Adler, who I think is speaking next week, has analyzed Chief Justice Roberts quite a bit. And I think he characterizes, some of his ruling as orienting from his judicial philosophy might be characterized best as anti-disruptive or non-disruptive. And so, yes, political in some sense of the word, but, so it might be a view of, we have this policy, this massive policy that 700,000 people have benefited from, are benefiting from. I don't want to create chaos. I don't want the court creating chaos. I don't want the Supreme Court creating chaos, right? And that, I think, bleeds into issues of where, many have written about this, that Chief Justice Roberts is hypersensitive to the court's standing in society, and wants it to be viewed as a legitimate institution, a nonpartisan institution, right? He's gotten into notable tiffs with the president, right? We don't have Obama judges and Trump judges, right? And so I think it was important to him to not disrupt it. DAPA, on the other hand, had not really gone into effect, the ruling. So it wasn't disrupting people's lives in quite the same way an adverse ruling would. That's certainly one explanation. Others have, and I suppose it's in the larger context of this whole different set of cases that you'll hear about. I mean, some have viewed Chief Justice Roberts as the most brilliant, he is playing the long game. And so he chooses his spaces, he chooses his cases, and there is a little bit of negotiation that goes on with the justices. And so, he believes he can, in essence, it's a way to sweet talk Justice Breyer or Justice Kagan gain their fidelity, and then, they owe him a favor, sort of a little bit of horse trading going on. That's one perspective as well. So I don't know. I mean, I as I say, I was surprised, as were many, by the outcome. I mean, it is a very strict reading of administrative law, a very demanding standard for the agency that and I'll talk in a bit about the dissents that the dissents raise, and sort of say, like, this is madness. This isn't the standard we apply normally to agency determinations. And so it may have ramifications well beyond this immigration context in terms of what level of review agency determinations will now be subjected to. Will they all now be subjected to as rigorous a review as Chief Justice Roberts demanded, or was this outcome determinative reasoning, right? That Chief Justice Roberts wanted to uphold DACA, and he found a way to do so. I will say, certainly people have also talked about, I mentioned the reliance interests piece to it. That, if we can move away from the cynicism and politics for a moment, Chief Justice Roberts may have been genuinely moved by the plight of these dreamers. And so, now you could say that's not the job of a justice. You're not supposed to let your sympathies prevail. You got to look at the law. But I think there are those who found their case, as does much of the public, so very compelling and heart-rendering. And so, again, found a way, that the head would support the heart, I guess. Don.
Yeah. Two questions, really. What was the impact of the fact that most of these DACA recipients had in fact entered the country illegally? And the second question, a separate one, is could these children, now adults, become citizens?
Sure. So the impact of their being illegally, I guess was understood from the outset, right? I mean, there was no question, no factual question here. Every one of these individuals, the 700,000 dreamers, is here in the country illegally. And so the question, really, again, just going back to it, and I don't want to repeat myself too much, but this was, you could look at it as an act of grace, right? That's what, you could characterize prosecutorial discretion, right? The DACA program was saying, these people are here illegally, but they're the result of their parents' illegal actions, in essence, right? They didn't have the capacity, right, to know they were doing wrong, so to speak. And so we are going to be generous to them. We are going to defer removing, though legally they could absolutely be removed, right? Again, some of this is, and the argument is that prosecutorial discretion has gone on, as I alluded to, forever in the immigration context, in the criminal context, right? You can't simply get rid of everyone. It's next to impossible, logistically, cost-wise. Here's a good group. If you're gonna prioritize who should stay and where you're gonna expend your resources, this is a good group. But the fact that they were illegal was understood, agreed on, by all parties.
But could they become citizens?
I'm sorry?
Could they become citizens?
So could they become citizens? Yes, they absolutely could. And I think here, gets to the larger issue of, what would be required of them. Some would say they need to leave the country and then re-enter legally, obviously get into the back of a very long line. But that would be one legal process. Hovering over all of this, and it's less the focus of my remarks, but is, of course, Congress could fix this in a heartbeat. And as I noted, right, there've been a couple dozen efforts in just the last couple of decades where Congress has tried to do so. So this is, depending on your perspective, President Obama and then President Trump fumbling, right, around with trying to figure out a solution. They can't make laws. And that's part of the question, that the dissents in particular are saying, is the president making a law now when he does something, creates a program like this? And was it illegal? But yes, citizenship could become an option. Again, it's a very difficult process as it stands right now, and I think, I would not be shocking whichever administration we see for the next 4 years, these battles over what kind of process we should create to address the, again, 11, 12 million undocumented individuals in this country is needed, right? Because right now we have a system where people are outside the law. And so DACA, the rescission of DACA, is an example of the executive branch struggling in that void. It's Andy. Hi, Andy.
Oh, hello. So would it be correct to say that if there's a second Trump administration, that they'll come back again and try to undo DACA by following Roberts' guidance?
So I learned long ago, I have no business predicting anything politics-wise, maybe not legally either. But that, of course, is a huge piece of speculation that I mean, everyone is speculating about. So, this decision came down in June. Theoretically, the next day, this is what people sort of talked about, right? I mean, that the Chief Justice's opinion is a roadmap for the administration to, here's how you write a proper memo to authorize rescission of DACA. And they could follow those, right? Almost like a, connect the dots memo on rescission. And ultimately, the Supreme Court would probably uphold it. So, why hasn't the administration done that? That's probably more, a political determination. Again, as I've noted, the Dreamers are sort of that, while on many issues related to immigration, I think the country is very divided. The polling I have seen suggests people are much more sympathetic to the Dreamers. So perhaps in this fraught election season, that's not what the Trump administration wants to do anytime soon. Would they afterward? I don't know. I don't know. I mean, that, there would obviously be legal fights over it again and again, regardless, but there certainly is a blueprint. I mean, they would know how to do it. And there's actually not a lot of fixes that need to be done that would then satisfy Chief Justice Roberts. And we know there's no equal protection worry either. So I think it could very easily be done. I think, that becomes much more probably a political determination than anything else. It's worth noting, well, maybe let me take a couple more questions because I'm going to come back to some of that, I think. All right, should I continue on? And then we'll maybe some more questions will arise, and we'll connect back to some of the things that you've all raised thus far. All right. So,
Want to take a break for 10 minutes?
Oh, that's what we're supposed to do. I apologize. Yes, let's do that. Thank you for reminding me. All right, we'll come back in 10 minutes.
Yeah, in about 10 minutes, so 2:42 about, and back then.
Security number for fraudulent activity.
End of messages. Wednesday, 2:02 p.m.
Security number for fraudulent activity.
End of messages. To delete all old messages, press
All right, hello everyone. We'll try and get back. I don't think I have by any means 40 minutes more to prattle on to you all. So I'll finish up with my remarks and then look forward to some more good discussion. So please, if you were holding your powder, let it rip after. So, all right, let me just go back to sharing the screen briefly with a few more items. Hopefully you now all can see in front of you Justice Thomas, who wrote the lead dissent in the DACA case. And I refer here to something called the non-delegation doctrine, saying that it lives. This is the idea I think I alluded to, but that has been held at various times, and it now appears there are at least 4 justices who perhaps support this proposition, that the administrative state, all of these various agency actions, may at times be legally questionable because they are in essence acting in the province of the legislative branch. That is to say, agencies are making laws, or all too often Congress is abdicating its responsibility, not providing enough guidance on policies, say about deferral on removal and immigration. And the agencies are acting in that void, but that to do so may be viewed as a violation of the non-delegation doctrine. That is, you haven't been delegated or haven't been provided clear guidance, and therefore you are engaging in lawmaking, and that is unlawful. And so in many respects, that undergirds a lot of Justice Thomas's reasoning. Now, I should note, Chief Justice Roberts' opinion does not opine on the legality of DACA. He doesn't say DACA was legal or illegal. He doesn't say whether it was a good policy or a bad policy. But Justice Thomas and the dissent, joined by Justices Gorsuch, Kavanaugh, and Alito, so 4, found that DHS had created DACA without congressional authorization. That in essence, this was a violation of the non-delegation doctrine. They didn't have authority to do this. So that's one reason why DACA was therefore illegal. It was unlawful in the view of the dissent. And moreover, they opine, it was done without following the proper notice and comment rulemaking process that's required under the Administrative Procedures Act. So normally when an agency is creating a rule, which Justice Thomas and the dissent construed this to be, there should be a notice and comment process where people can provide, just as it sounds, right? Notices, commentary, the idea being that this is a transparent and somewhat democratic process by which agencies come to rulings. And having not done so, and having not had proper statutory authorization, DACA is unlawful. And if DACA is unlawful, why should the DHS under the Trump administration have to go through all of these machinations that Chief Justice Roberts is requiring under the APA? Why can't, just as Obama's DHS acted unilaterally, why can't the Trump DHS do the same? Right? What is good for the goose should be good for the gander. Now, the response in part to this from Roberts is, again, that it's sort of immaterial whether it's unlawful or not. There is an administrative agency process by which, in undoing a policy, the agency must engage in that. It is not entirely for them to, they can certainly make that determination. They can eliminate the policy. No one is disputing that the agency can eliminate the policy. But where we have a system where policies change from administration to administration, there has to be a minimum. And Chief Justice Roberts would maintain it's not a lot, right? But you have to go through a reasoned exercise and consider things in full and consider reliance interests. That was not done. And it shouldn't matter if DACA is lawful or unlawful. That's required under the APA. So Justice Thomas, will have none of that, and that's certainly one argument that he makes that is predicated on the illegality of DACA. There is another argument that he adopts, but Justice Kavanaugh really writes more about this, which is that, and this gets a little more. People have questions. We can get into the murkiness here, but there was a follow-up memo written as a consequence of lower court litigation by Secretary Nielsen. You may remember Secretary Nielsen, who followed Secretary Duke in the DHS. And the lower court had said, you haven't given us enough good reasons to scrap DACA. And Secretary Nielsen offered more reasons, elaboration on that. Justice Kavanaugh argued those additional reasons should have been considered. And Chief Justice Roberts, in response to that argument, said, no, you only consider the reasoning that is provided contemporaneous with the change in policy. That is to say, and it's almost, I suppose, to be analogized to, litigation reasons, right? Or after the fact rationalizations for a policy. And that can't cure it. So that was an important, pivotal debate between the dissenters and Chief Justice Roberts. With respect to the equal protection dissent, and remember, Justice Sotomayor is alone here in her dissent. Mr. Schnall, you asked about, how can we understand, what was Roberts doing here? You might ask also, what were the other, traditionally liberal, again, Democratic appointed justices, Breyer, Kagan, and Ginsburg going along with Roberts on the equal protection argument. That was somewhat of a surprise as well. And so Sotomayor writes alone, disputing the Chief Justice's reasoning here. And she says, first and foremost, looking at the president's comments, that they absolutely bore on DACA, that essentially, unlawful migration from Mexico was sort of the centerpiece of his campaign, the keystone, and a policy priority. And this is what explains DACA. So she did not buy the remote in time, remote in context argument that Chief Justice Roberts articulates. And she argues with respect to the disproportionate impact, that has to be read in light of the statement. So I suppose some conceding that, yes, the disproportionate number of Latinos from Mexico can, of course, be explained by the fact that they are the country's immediate southern neighbor. But conjoining that with the statements, we get closer to some sort of purposeful discrimination. And then finally, this abrupt change in policy, she argues, was not business as usual. And one aspect that I think sometimes does get lost, and I don't think is in the opinion, is that as the Trump administration sort of pivoted, about DACA, loving the Dreamers, doing action there, it was threatened with litigation by 10 states, Republican attorneys general, who said, we're going to sue you over DACA, essentially, if you don't do something. And fairly quickly thereafter, there was this change in policy. Whether that supports invidious discrimination is another matter, but again suggests, there were other explanations for the change in policy, that might not be business as usual. We talked a little bit about this based on Mr. Schnall's question, I think, which is trying to make sense of how it was that Chief Justice Roberts authored this opinion that seems, again, was surprising to people. Again, I think we've sort of you know, we can certainly engage in more discussion, but I think this encapsulates some of the ideas we were talking about, which is to say, you know, one of this is this horse trading and, you know, giving and taking and what have you. Another, simply won over by the compassionate and sympathetic situation of the Dreamers, the Reliance interests. And finally, an institutionalist piece, which again, some of it is what my colleague John Adler has talked about, sort of this non-disruptive principle. You'll talk in a few weeks with Professor Jesse Hill about reproductive rights, and you know, there too, Chief Justice Roberts surprised folks. That might be seen again as an example of non-disruption, a fairly recent ruling by the court that he didn't want to disturb. And so, you know, again, this is guarding both, you know, sort of a status quo situation. We don't want to be too disruptive where it could really cause, you know, wreak havoc in the country. And institutionalist also in the sense of protecting, I think, the reputation of the court as an honest broker, if you will. Mr. Cohn, Andy Cohn asked sort of, you know, what might the administration do? And you know, I've demurred there a little bit in terms of what they might do. Again, as I said, there is sort of a roadmap. If the administration wants to write a new memo and rescind DACA, that is certainly something that they could do. Again, I think there would be litigation over it. Now, what is happening in the immediate, however, I think is worth noting. You know, the court indicated at the end of its ruling that the matter should be remanded to lower courts to you know, make determinations consistent with the reasoning of this opinion, and suggested it should be remanded to DHS, right, to reconfigure a policy. Now, in July, mid-July, a district court in Maryland ruled that in light of the Supreme Court opinion, the DACA program pre-September 2017, so the DACA program from the Obama administration should be reinstated, and DHS should start processing applications for DACA. So DHS actually did issue a ruling at the end of July, in which it now has barred any first-time applicants, so people who are eligible for the first time for DACA, and there are now, I believe, almost 70,000 people eligible to apply to DACA. So essentially people since 2017 have become eligible, almost 70,000 people. So they're barred under the new DHS rules. Work renewals are now limited to 1 year rather than 2 years. And travel outside the US is limited under the new rules. So that is now a source of challenge. Some are arguing, the plaintiffs in one of these cases are arguing that this places the administration in contempt of both the district court, but also of the US Supreme Court. So that's certainly an issue to look out for. And that's been ongoing since the summer, sort of fighting over this. And DHS has said in some of those court filings, it is reviewing the opinion still, and certainly could terminate the program. It's not suggesting that, you know, that's not an option. And then finally, as I think I noted at the outset, is, again, some people may have read this in the news today, a case coming out of the Ninth Circuit called Ramos versus Wolf. And this case concerns what is known as temporary protected status. Now, this is a program, in contrast with DACA, it is congressionally authorized, and it allows for the Department of Homeland Security to make determinations, humanitarian determinations, that people from various countries may stay here for temporary periods of time because of humanitarian crises in their country. And they might be war-related. So Syria is a good example of a country where there is temporary protected status. Anyone within a certain time period and reaching here, I mean, they do have to apply, would be eligible for temporary protected status. Ramos versus Wolf is a ruling, again, that came out just yesterday, and relying largely on the DACA case, held that plaintiffs challenging the DHS's termination of temporary protected status for Sudan, Nicaragua, El Salvador, and Haiti had not satisfied the equal protection claim test for tourists. Now, just a word here, and I'm getting a little bit in the weeds, but here there was no real APA claim. There actually is a bar on judicial review of temporary protected status determinations, right? This is something clearly committed to the discretion of the executive. They're making determinations that it is not safe in Haiti, or it is safe in Haiti, and people can return. That is not reviewable. What is reviewable are constitutional claims. And so here too, an equal protection claim was made, again, relying largely on President Trump's various statements. May recall in particular, and what was noted in the complaints were references to particular African countries and disparaging remarks he had made there, but also others. But the court, again, citing the DACA case, well over a dozen times, basically says, look, just as the Supreme Court ruled that those statements don't support evidence of a discriminatory purpose, neither do they here. And the consequence is that many of these people who have been here for, in some cases, decades, on a temporary protected status can be removed. I mean, I don't believe any of it, none of them is removable until 2021, but it certainly, will impact people's lives significantly. So again, just one small, indicator, just in today's news, of how the DACA case has wider ramifications, not simply within the Dreamers context, not simply within the Mexico-U.S. border context. And so this is the state of affairs that is present. I think it is worth noting that in the absence of congressional action, which people can attribute to either cowardice or lack of cooperative spirit, for lack of a better word, collegiality, the president ends up, right, by default, taking action and having a lot of authority. And that can be regardless of which partisan stripe you have. The president has an enormous amount of power, I think probably across the board. But where we address issues of immigration in particular, and one can think of the travel ban case from a few years ago as similarly reflective of that, the president can act in this void, and the court is often quite deferential. Probably one important distinction here is that in dealing with immigration here, we're dealing with people who are in the country, and different standards do apply there. But we have seen the Supreme Court quite deferential to this president with respect to the building of the wall, with respect to policies relating to preventing refugees and those seeking asylum from coming into the U.S. and working out various deals to stay in Mexico and elsewhere. It's not really a surprise that the administration would be so deferential. Because again, in the absence of congressional action saying otherwise, the president has enormous power, wields it, and the court is usually reluctant to disturb it. So this is an extraordinary case in that regard. Though again, the fact that it dealt with individuals within this country, regardless of whether they are citizens or not, I think does influence a little bit the outcome. I am going to make sure now to stop sharing my screen and open it up to folks. There is a chat I see from Thalia Dorwick asking, is the roadmap vulnerable? How could it be challenged? And so again, that's, I guess, the reference that I described, that Chief Justice Roberts has explained fairly succinctly how a Department of Homeland Security, now Chad Wolf, could write a memo that would probably satisfy his standards. I think, I mean, ultimately, I think the reality is that the Supreme Court would probably uphold it. I mean, if a Department of Homeland Security secretary were to read this opinion carefully, I think the guidance is quite clear as to what is needed, right? So I think, you consider, as it's suggested, right? Consider why deferral of removal is not a viable option. Right? And give sufficient reasons for why it is not. Address the reliance interests sufficiently. And I don't, again, think all that would be required. The government sort of after the fact, again, during litigation, argues that, these weren't, how could these be reliance interests? These are temporary benefits. Right? It's a 2-year renewal, right? You don't get to stay in the country forever. So does that temporary nature really create a reliance interest? That's a fair argument. That's a fair question to be raised. Were the memo to engage in that, that might satisfy the consideration. But none of it was there. And so how could it be disturbed? Again, lawyers will litigate anything. There are advocates who care passionately about this and obviously don't believe that the dreamers should be removed. I think they will find a sympathetic district judge somewhere. Might not be the Northern District of Ohio, but it could be, but it could also more likely be in Northern California. And these judges, an individual judge can issue a nationwide injunction, right? Which would stop the policy everywhere across the nation. And then litigation can take a while. And that's not insignificant, to the extent one is sympathetic to the cause of the dreamers, every day in this country would be meaningful. But I would predict that, again, if the memo is written properly, and I think, sadly, particularly in the Department of Homeland Security, there's been some pretty bad memo writing, some pretty bad lawyering in terms of meeting these basic standards that have made it very easy for a Chief Justice Roberts perhaps to strike them down. But I would think ultimately, again, if that memo is written carefully and thoughtfully, the Supreme Court would uphold a rescission of DACA. Because, again, as I say, and it's clear in the opinion, everyone agrees that an administration would be within its rights to rescind DACA. It's a matter of policy. The question is you have to do it properly, and that's what the Administrative Procedures Act requires. Don Goldman asks, did any of the other liberal justices write a concurring opinion on the equal protection issue? And if so, what did it state? No, they didn't. So yeah, we're left, and again, I was a little bit surprised by it. Though, it's worth noting, I think as we get into this area of immigration, again, as I sort of what I ended my remarks, the president is given more deference. I think if this were squarely a domestic issue in every sense of the word, there might have been less deference to the president, and you might have picked off a Breyer or Kagan or Ginsburg. It's worth noting in the travel ban case, only Sotomayor writes a virulent dissent there, suggesting that the travel ban was motivated by anti-religious sentiments. Only Justice Ginsburg joins her in the dissent in that respect. Right? There are 4 dissenters in the case as a whole, but as to, and there, I mean, it's akin to equal protection, but it was religious discrimination under the Establishment Clause. But only Ginsburg joins Sotomayor there. So, I think, I'll say also, what it does raise, and I remember actually, I think talking with folks here in the Siegel program, when we discussed the travel ban case, one of the arguments that is raised is that a lot of the statements made by Trump were not as president, but while he was campaigning. And should campaign statements be held against a policymaker has been raised as a question. The other actually just wrinkle to all of this is, of course, these cases aren't Regents versus Trump, right? This is a case versus the Department of Homeland Security. And so one argument is, yes, Trump said all those things, but Secretary Duke didn't. And those should be separated. You know, there's no necessarily showing evidentiary-wise that the president's remarks influenced her policy making. Now, I'm sure if we took a poll here, people would have different views on whether there was an impact. You know, President Trump is, of course, her boss, but you know, should there be some sort of transitive property there is raised. Linda asks, what needs to happen to make Congress do their job on immigration reform? What are the prospects for this after the election outcome? I can't speak to that. I mean, I say that only, and I mean, you know, as noted at the outset, for decades, this has been an albatross around Congress's necks, and nothing has been done. So I don't know. I don't know. I certainly would yearn for it, and I say that without. That's not from a partisan frame perspective. And I think probably people on both sides of the aisle believe there should be some solution. There needs to be clarity. It does make a mockery of the rule of law, and I don't think it's good for anyone, you know, to be undocumented in our system, in our society. Is Chief Justice Roberts believing there will be a change in administrations, giving them some guidelines? I don't know. I don't think so. I mean, I think, again, you know, I've characterized it as a roadmap. I don't think there's anything so extraordinary in Chief Justice Roberts, you know, laying out what would be proper. You know, I mean, that's sort of fidelity to the law. It certainly raises an interesting question, right? If a Biden administration reified DACA, there would undoubtedly be legal challenges. And I suppose it goes back a little bit to Mr. Schnall's question. So, you know, where would Chief Justice Roberts be? Because I suppose there is guidance for a Biden administration, right? They could remove now this conferral of benefits, right? Maybe just defer removal. Now, again, you can wonder about how welcome that would be to most people. You want to be able to stay in this country but receive no benefits and not be able to work. That's probably not good for society, nor good for the dreamers. Is DACA dead in the water if Trump is reelected, to let the dreamers who want to apply for the first time not going to be allowed? You know, here too, I don't know. Again, I mean, the polling, I think I saw, I tried to pull some before, you know, you can't rely on everything you read or pull off the internet, but I think I saw something like, you know, even, again, if you put it in partisan terms, I think 66% of Republicans support the dreamers and support the, you know, that aspect of the policy. So I don't know. You know, again, this gets trying to be, you know, be a mind reader of the president. So I think hard to say what would happen. William Howard, Bill asks, is the tone and language of Thomas and Alito characteristic of the court, not deferential, not respectful, and that we saw this in Bostock? I think we are seeing, I think it may be characteristic of the new court. And I think we've seen this now probably for a couple of terms. Yeah, there is some pretty incendiary language. And you know, coming, you know, it can come, I think, from both sides. You know, Sotomayor is no soft-spoken, does not have a soft pen either. But yeah, there is certainly caustic language that comes from here. I suppose, and you know, I don't want to be Pollyannish about this, but I think it does speak to how sensitive, how controversial the issue of immigration is in our society. I mean, I think it clearly galvanizes emotions and divides people, and you see that, I think, in Thomas and Alito's framing. Any other comments, questions?
Anybody have questions they want to ask live rather than typing into the chat box?
This is a ridiculous question. The same restrictions apply to immigrants from Nordic Europe.
So, I mean, DACA is applicable to everyone.
Okay.
So there is no, I mean, by its terms, it is not, it is neutral. And so, I suppose, again, that is somewhat reflected, again, in Robert's response to the disproportionate impact argument is, yeah, there are more dreamers who are Latinos from Mexico. That's because they represent a larger share of the undocumented population. And, for a variety of reasons, economics that influence immigration, I think, and obviously just, a very long southern border that the U.S. has with the northern border of Mexico explains, how porous it is, notwithstanding a half-built wall. But yes, it would apply to anyone and everyone from regardless of country.
Okay, thank you. Great talk.
So Sid asked, does Congress legislate what countries have TPS status, or is it administratively done? So Congress has the authority to legislate, but it provides and gives the discretion to the executive branch. Specifically, the State Department actually often makes those determinations in concert with the Department of Homeland Security. And again, I mean, that's where, that's a logical exchange of responsibility. Congress creates a law, right, broadly framed, says we recognize there can be a need for this sort of emergent humanitarian relief. We don't have the time to continually in perpetuity be assessing the situation in Botswana, Uganda, Haiti, El Salvador. That's for the executive branch to do. And when they make a determination, right, we're not going to disturb it. So the short answer is that it is largely administratively done. And so the logic there, and again, there is a specific bar on judicial review for these determinations, right? There's sort of an understanding of, it's not the court's business to say if a civil war has begun or ended in El Salvador. That is for the executive branch to do. The only time when the court can get involved, as I noted in the Ramos case, is where a constitutional claim is being raised. And so that's where this equal protection claim has been brought up. And there you have the outcome. Does the law set the parameters of the rationale? Yes, right. So again, there needs to be some, in administrative parlance, there needs to be a clear and intelligible principle. Blanking, I don't believe I have it in front of me specifically what are the parameters of that rationale. But yes, there is guidance for the executive branch. They can't sort of just, completely make out of whole cloth the basis for a TPS determination. Though, if you felt that they had, that wouldn't be judicially reviewable. So, there is that tension there.
I think maybe that's it. Everybody is sated. All of their questions have been answered.
Well, I really enjoyed this, and I suppose the wonders of Zoom, as much as it would be lovely to be talking with you all in person, are you know, I'm always happy to talk with someone over Zoom outside of the confines of Siegel Lifelong Learning. So, you know, reach out. You know, my email is easy enough to find. And hopefully one day we can, I don't know, talk about another term of the court in person.